The courtroom didn't explode. It emptied, not physically, emotionally. The air went thin like the oxygen had been quietly sucked out of the room the moment the judge finished speaking. No shouting, no gasps, just a silence so heavy it felt like pressure on the chest. And right there, in the middle of that silence, sat Prince Harry. Not a royal, not a headline, not a symbol, just a man who suddenly realized the story he had been telling for years had slipped out of his hands. Because this was supposed to be the moment of reckoning for the press. Instead, it became a reckoning for him. He had come into that courtroom armed with history, pain, and a narrative the world already believed. Years of feeling hunted, years of claiming intrusion, betrayal, and unseen forces shaping the worst chapters of his life. He spoke about fear like it still lived in his bones. He described relationships buckling under pressure long before Meghan ever entered the picture. He made the courtroom feel the weight of it, and for a while, it worked. People listened, they leaned forward. His voice carried emotion that didn't feel rehearsed. It felt lived in, raw, personal. He wasn't just presenting a case, he was reliving a life he believed had been dismantled by headlines. But courts don't decide cases on emotion, they decide them on structure. And that structure started cracking. It didn't happen in one dramatic moment. No Perry Mason twist. No single answer that detonated everything. It was slower than that. More dangerous. Adrift. Tiny shifts in how he described what he knew and when he knew it. At first, the differences were easy to miss. A phrase here, a clarification there, a subtle adjustment in how certain events were remembered. But the judge wasn't just listening to answers. He was listening to patterns. And the pattern didn't sit right because Prince Harry's case leaned heavily on one idea that certain stories printed about him could only have come from unlawful intrusion, that the information was private, unknown, impossible to obtain by legitimate means. That claim was the backbone, but under questioning, something uncomfortable surfaced. Moments where he acknowledged conversations behind closed doors, instances where he admitted assumptions were made at the time, not certainty, but belief, places where hindsight blurred with memory, where what he now felt must have happened wasn't quite the same as what he could prove he knew back then. The judge didn't accuse him of lying, he did something worse. He started asking for alignment. Did you know or did you believe? Did you learn this then or conclude it later? Was this memory or interpretation? They sound similar. They are not. And as those questions stacked up, the emotional certainty Harry had carried into the courtroom began colliding with legal precision he couldn't bend. You could see the shift before you understood it. His posture changed, subtle. Shoulders no longer squared in quiet defiance, but held tighter, like someone bracing for impact. His pauses stretched longer. His eyes dropped to the desk more often, not in shame, in calculation, replaying, reconstructing, searching for the version of events that still fit together cleanly. But courts don't run on the version that feels true. They run on the version that stays true under pressure. And the judge, calm, almost gentle, laid it out piece by piece. Not dramatic, not cruel, clinical, precise. He spoke about inconsistencies not as attacks, but as unresolved tensions in the testimony. Places where explanations didn't quite lock into place. Points where knowledge appeared earlier than the narrative allowed. Then came the moment that changed everything. Not a verdict, not a punishment, a doorway. The judge explained that some of these inconsistencies could not be fully resolved within the boundaries of a civil case. That certain questions about sworn testimony, about how it was framed, what it implied, and whether it might have unintentionally misled the court might fall outside his jurisdiction, which meant they might need to be looked at elsewhere. He didn't say the word loudly, he barely said it at all. Referral to the Crown Prosecution Service. And suddenly this wasn't just Prince Harry versus the press, it was Prince Harry versus the weight of his own words under oath. You could almost feel the moment hit him. Not a collapse to the floor, not theatrics, something quieter and more devastating. A stillness. The realization that this case was no longer something he could control with interviews, statements, or public sympathy. Once a court signals that sworn testimony might require external review, the story leaves the realm of narrative and enters the realm of process. And process does not care who you are. The judge made it clear this was not a finding of guilt, not an accusation, not a charge. It was a procedural step, a recognition that the integrity of testimony itself might need independent scrutiny. But in that courtroom, everyone understood what it meant. The fight he thought he was leading had turned around. The system he came to challenge was now examining him. When the session ended, there was no dramatic exit, no outburst. Harry stood, gathered his papers, and walked out the way he came in. But he did not not walk out the same man, because the question was no longer just what did the press do to Prince Harry. Now it was also, did Prince Harry's own testimony cross a line the court cannot ignore? And once that question exists, it doesn't disappear. Outside the courthouse, cameras hunted for a moment that never came. No tears, no shouting, no dramatic gesture to freeze into a thumbnail. Just a man moving through a crowd of microphones like someone walking through heavy rain, head slightly lowered, expression locked in place, thoughts clearly somewhere far beyond the noise. But inside that courtroom, something irreversible had already happened, because the legal battle Prince Harry thought he was fighting had split in two. On one side, the civil case against the press, still alive, still technical, still grinding forward through documents and legal arguments. On the other, a quieter, more dangerous question now floating above everything he had said under oath. Not was he hurt, not did the press behave badly, but can the court rely on his version of events the way the law requires? That shift is brutal, because it strips away sympathy and replaces it with scrutiny. And scrutiny has no emotions. In the days that followed, legal analysts began circling the same uncomfortable truth. This was never about one dramatic contradiction. It was about cumulative instability, a story that held emotionally but shifted mechanically, a narrative that made sense in lived experience but struggled under the microscope of legal precision. Prince Harry had spoken from memory, from feeling, from years of believing he had been targeted in ways no one else could understand, and that belief may be genuine. But courtrooms don't test belief, they test provability. The judge had made that distinction painfully clear. Under oath, you don't just tell what felt true, you tell what can stand still when examined from every angle. And when parts of that story seem to move, even slightly, the court doesn't ask whether you meant to mislead. It asks whether the result did. That's the part people outside the legal world struggle with, because in normal life, inconsistency is human. In court, inconsistency is risk. And once risk appears around sworn testimony, judges don't have the luxury of ignoring it. So the focus turned to process. Quiet, administrative, relentless. If a referral were to proceed, it would not be loud. There would be no press conference, no immediate drama, just files moving from one desk to another. Legal minds reviewing transcripts line by line, not asking whether Prince Harry seemed sincere, but whether the structure of his testimony could have materially affected the court's understanding of the facts. That kind of review is cold, detached. It doesn't care about public image or royal history or media narratives. It asks one thing: was the oath honored in the way the law demands? And that question is terrifying precisely because it's so narrow. Meanwhile, the public conversation fractured. Some insisted this proved he had been reckless. Others argued he was being unfairly cornered for being human in a system that demands robotic precision. Supporters said trauma clouds memory. Critics said memory cannot cloud sworn evidence. But none of those debates changed what mattered most: the machinery had been activated. Prince Harry was no longer just a claimant seeking accountability. He was now also a witness whose own credibility had become part of the legal landscape. And credibility, once questioned in one courtroom, doesn't stay confined there. It echoes into future cases, into negotiations, into how every future statement under oath will be received. That's the silent cost, not a dramatic fall, not a single explosive moment, a slow erosion of certainty, a shift from storyteller to subject, from someone demanding answers to someone being asked for them. Inside legal circles, the moment was already being described not as a collapse of a man, but as a collapse of narrative control. Because once a judge signals that a witness's words may need external review, the story no longer belongs to that witness. It belongs to procedure, and procedure has no loyalty. Prince Harry had spent years fighting what he saw as a system that fed on distortion, intrusion, and narrative manipulation. He walked into court believing the law would finally put boundaries around that chaos. Instead, he discovered the law draws its sharpest boundaries around truth itself. Not emotional truth, not moral truth, but factual, structured, defensible truth. And if your story lives more in feeling than in fixed points on a timeline, the courtroom becomes a dangerous place to tell it. The image of him leaving that day lingered not because he fell, but because he didn't. Because he held himself together while the ground beneath the case shifted in ways he could not immediately fight. That's what made it powerful. A man used to battling headlines suddenly facing something headlines can't fix. A process that doesn't care about public support. A review that doesn't run on outrage. A system that moves quietly, methodically, and without performance. And hanging over everything was the same unresolved question the judge had effectively placed on the table. When memory, belief, and narrative collide under oath, which one does the law choose to trust? For Prince Harry, that question is no longer theoretical, it's procedural. And once the law starts asking procedural questions about your words, the loudest battles are already over. What remains is silence, paperwork, and the long shadow of testimony that wouldn't quite line up, a shadow that follows you long after the courtroom doors close.